So, dann kommen wir jetzt als nächstes.
Which brings us on as the next point to Mr. Karim's report. This is point 27 on our agenda. Mr. Karim.
Sie haben das Wort.
You have the floor, sir.
Ich sage mal eine Minute.
Or wait, maybe we ought to wait a minute until everybody who needs to leave the room has left the room, because otherwise you're not going to be able to give a decent presentation of your report. So please, to those people who are not going to be participating in the debate, please leave the room as quickly as possible so that Mr. Karim can present his important report to us.
Okay.
That works well now.
Es lichtet sich und es wird übersichtlich.
Everything's clearing a little bit. We've got a better overview of everything. So, Mr. Karim, 27 and 28.
Chairman, thank you. Colleagues, I'm pleased to be able to present today my two draft reports, which cover the Commission's proposed amended statutory audit directive and the new regulation, which is directed towards requirements for the auditing of PIEs or public interest entities. Chairman, I've got a lot of back chatter which is preventing me really from being able to concentrate on what I'm wanting to say.
Karim hat vollkommen recht.
Mr. Karim is quite right. So please make sure that you have all your chats and conversations outside the meeting room and not inside the meeting room.
Gut. Wir machen einen zweiten.
Well, a second attempt.
I would like to begin by thanking the Commission and Jury Secretariat for the assistance they have given in the drafting process so far. Although this is, of course, only the opening round and there is still much work to be done. Before the summer, I presented my working document addressing a number of key policy issues arising from the reform of the statutory audit. The issues raised therein and picked up in the committee debated thereafter are in the main areas for debate: mandatory rotation, provision of non-audit services, oversight bodies, and so on. The various policy options open were explored in the working document and debate, and today I have put forward my proposals for a considered way through the myriad of possibilities when it comes to designing an efficient, effective, and robust process around statutory audits and the practices of the auditors. As I mentioned during the last exchange of views, my overriding aim has been to strengthen audit quality and to provide investors with the information that they need. Turning to the draft reports themselves, I will first explain some of my proposals on the directive. I have put only a few amendments to this file, mainly concerning the role of professional bodies in the oversight of the audit profession and the definition which is given to public interest entities. In relation to public oversight, I have been consistent in my approach towards retaining the possibility of involvement of professional bodies in a number of important tasks which are undertaken by national authorities. In this regard, I have proposed to retain their involvement in the education and qualification of auditors and the quality assurance reviews of firms not carrying out PIE level audits. I understand the Commission's wish to keep much of the oversight function within the control of national authorities, but I consider that a mixed model, such as those practiced in the UK, allows the best balance between guaranteeing independence in the public functions exercised by the oversight body and ensuring that the national administrations are able to carry out the tasks given to them with the most up-to-date expertise. My proposals around the definition of public interest entities represent initial thoughts, which are that the blanket inclusion of certain types of investment and other entities providing financial services would be a disproportionate response. We do perhaps need to go further, and this is particularly evident when you consider some of the entities that would be caught by this provision, such as village shops providing postal services, certain mutual funds and credit unions, and even some charities. Whilst it is important that these organisations are run well, it does not seem necessary to me to require the local post office to establish an audit committee. I think in this area it is important to look for consistency with other legislation which would be applicable, and clearly the accounting directive would represent a logical place for alignment. I would therefore expect a further develop ideas along such lines during the amendment process to come, and hope my shadow rapporteurs would agree with such a move. Looking now to the regulation, it does not seem necessary to go through each individual revision, as there are many, but perhaps it would be helpful to pick out a couple of major changes and to offer some clarification of thought on a few items. Firstly, the audit report. On this article, I have made significant alterations to develop the good basis put forward by the Commission and introduce a few new concepts which are being developed at the international level. I consider my proposed article to be ambitious in trying to keep European legislation at the leading edge of international developments, in particular via a widespread adoption of an auditor commentary, which would help to increase the value of the audit report to shareholders and the wider investor community. I have also proposed new wording on the issue of establishing whether the audited entity is a going concern, to also develop that concept in line with international approaches. The intention is therefore to conclude with an outline audit report in the regulation, which delivers for investors and shareholders while being simple and concise for preparers and auditors to get to grips with. By taking the emphasis away from a kitchen sink approach back towards something closer to a succinct, targeted report drawing attention to the most important issues, I think the shadows will agree that developments in this area are on the right track. Concerning non-audit services, much attention has been paid to what services should and should not be provided to audited entities and by whom. My approach has been again to seek alignment with the international standards and codes. Many of the companies that will be caught under the regulation will be multinational organisations with statutory auditors in various different countries. It does not make sense to have wildly different rules in each jurisdiction for this type of engagement, just like we have seen in relation to country-by-country reporting in the accounting directive just voted. I have therefore aligned my provisions on this issue with the ISBA Code of Ethics, which sets down a series of guidelines for the provision of non-audit services and precludes the provision of these where an irresolvable conflict of interest may occur. I have proposed to prohibit those services which the Code establishes are always to be seen as causing a conflict of interest, and to require the Audit Committee to approve all other non-audit services, to ensure that they are fully aware of all activities under the audit engagement. I have also maintained my previous position that I do not see a need for the dissolution of large audit firms into pure audit firms. I think this would be an excessive intervention into the market, which would lower the quality of services provided and opportunities for our young people looking to start off in the profession. Finally, Chairman, colleagues, concerning auditor appointment, I have introduced some alterations to the basic Commission proposal. I do not agree with the Commission that mandatory rotation should be the normal method by which an auditor is appointed. I consider that audit committees should be trusted with control over the audit appointment process, and I am confident that they are fit for the task. I am doubly confident that they are fit for the task because I hope that many of the disclosure requirements introduced in the regulation will further empower shareholders to be able to take a stance on the appointment and conduct of the auditor and to pressure the committee when problems with an auditor occur. I do, however, have some concerns over excessive tenures, some of which can be seen in my own member state. I think it is therefore appropriate that it should not solely be the audit committee who can exercise power over the appointment procedure. I have therefore proposed that a maximum tenure should be set of 25 years to guard against unduly long engagements where it is clear that the perception will be one of scepticism but of the auditor's independence. I have only briefly touched on many of the aspects contained in my report, and I look forward to the comments of colleagues and to the future discussions, which I'm sure will be more in-depth and detailed. As ever, my door is open to all the shadows and other interested members, and I anticipate a good debate both within Parliament and with the Commission and the Presidency, with the final result being a valuable reform of this important area in company law. And just as a final sentence, in the very clear assurance that I provided to Commissioner Barnier in Strasbourg last week, I maintain my position that maintenance of the status quo is not an option. Thank you.